MP Béranger.
Et 378.
Mr. Speaker, sir, as the House is aware, a court of investigation was set up on 18th of September 2020 to investigate into the casualty at sea of the MV Wakashio, which occurred on 25th of July 2020. The court of investigation was chaired by Mr. Abdul Rafiq Hamad, GCSK, former puisne judge, and comprised Mr. Jean-Mario Geneviève, licensed marine engineer and marine surveyor, and Mr. Johnny Lam Kai Leung, marine surveyor, as members. It is apposite to note that in the aftermath of the grounding of MV Wakashio, and prior to the setting of the Court of Investigation, Government had on 21st August 2020 set up a technical committee on innocent passage of foreign vessel under the chair of the Secretary to Cabinet and Head of Civil Service to examine ways and means by which the territorial sea of Mauritius could be protected from incidents such as oil spills which could occur as a result of the innocent passage of foreign vessel. Moreover, on 28th August 2020, Government also examined the report of the preliminary inquiry on the grounding of MV Wakashio carried out by the Deputy Director of Shipping. It was agreed that the findings and recommendations contained in the report of the preliminary inquiry would also be taken on board by the Technical Committee on Innocent Passage. On 23rd December 2022, Government took note of the report of the Court of Investigation dated 15th of September 2022 and agreed that the report be not made public. As requested by the Court of Investigation, certain recommendations in the report be submitted to the Director of Public Prosecutions for action, and an inter-ministerial committee under my chair and comprising the Vice Prime Minister, Minister of Local Government and Disaster Risk Management, the Minister of Environment, Solid Waste Management and Climate Change, the Attorney General, and the Minister of Blue Economy, Marine Resources, Fisheries and Shipping be set up to examine the recommendations of the Court of Investigation and come up with a way forward. Mr. Speaker, sir, as regards Part A of the question, I wish to inform the House that I chaired an interministerial committee meeting on 8th of May 2023 to examine the recommendations contained in the report. During the meeting, it was also agreed that the Technical Committee on Innocent Passage of Foreign Vessel would pursue the implementation of the recommendations made in its report. In addition, the Interministerial Committee agreed that the Technical Committee would examine the findings and recommendations contained in the report of the Court of Investigation and come up with proposals for consideration. Subsequently, the Technical Committee held 3 meetings, namely on 19th of May 2023, 14th of August 2023, and 13th of February 2024, respectively, whereby an in-depth analysis of the report of the Court of Investigation was made, in particular, with regard to the recommendations made therein. It was noted that out of the 60 recommendations contained in the report, 18 had already been implemented, and 34 were being implemented by different ministries and departments. The remaining 8 recommendations did not require further action. Mr. Speaker, sir, the second meeting, which I chaired on 18th of March 2024, laid emphasis on the progress made by the Technical Committee in the implementation of the recommendations made in the report under 4 categories, namely, first, legislative amendments as well as enactment of new legislation. Second, procurement of equipment. Third, training. And fourth, other related matters. Mr. Speaker, sir, the Interministerial Committee took note of the actions initiated by the different ministries, departments for the implementation of the recommendations under each category as follows. Amendments to existing legislation, namely the Environment Act, the repeal of the Environment Protection Act and its replacement by the Environment Act, which has incorporated a number of recommendations contained in the report and which was passed in the National Assembly on 14th of May 2024. The Merchant Shipping Act, for which 2 consultants were appointed by the International Maritime Organization in January 2024 for the review of the said Act. They have submitted a report on 29th April 2024, which is currently being analyzed by the Ministry of Blue Economy, Marine Resources, Fisheries, and Shipping. As regards new legislation, this includes the Merchant Shipping Liability and Compensation for Oil Polluting Damage Bill, being debated today, will have a compensation regime for polluting damage, discharge, or escape of cargo oil from tankers, on par with that of most overseas jurisdictions. Specifically, the bill, if enacted, will ensure the payment of adequate, prompt, and effective compensation for pollution damage. Legislation for the establishment of areas to be avoided. The areas around the coasts of Mauritius and Rodrigues have been demarcated with the objective of providing a safe distance between ship lanes and the shoreline of Mauritius. In this connection, a merchant shipping notice was issued in 2020 to inform the shipping community of the establishment of the areas to be avoided. Moreover, our proposals for demarcation would be forwarded to the International Maritime Organization by July 2024 for consideration at its meeting of September 2024. Legislation for the setting up of aids to navigation. The Republic of Mauritius will soon sign a Memorandum of Understanding with the Republic of India, represented by the Directorate General of Lighthouses and Lightships, for the setting up of an Aids of Navigation Authority unit for Mauritius. Concerning procurement of equipment, this includes purchase of oil spill equipment. A number of equipment are already available to combat oil spill, and additional equipment has been obtained through donations. Furthermore, the Ministry of Environment, Solid Waste Management and Climate Change has initiated procurement procedures for the purchase of state-of-the-art oil spill combat equipment to enhance preparedness capability regarding oil spill in our exclusive economic zone. Acquisition of a coastal surveillance radar system. The Japanese authorities hired a consultant to work out the design as well as the bidding documents for the acquisition of a coastal surveillance radar system. The technical specifications for the acquisition of the coastal surveillance radar system were finalized after necessary consultations, and tender was launched by the Japanese authorities on 10th of May 2024 with closing date of 10th of June 2024. Acquisition of tugs. The Mauritius Ports Authority also intends to procure 2 big new tugs of about 80 tons bollard pull at an estimated cost of 1.2 billion rupees and 4 small tugs with bollard pull of 15 to 20 tons at an estimated cost of 600 million rupees with the assistance of friendly countries. As regards training, the Japanese International Cooperation Agency is assisting Mauritius in terms of technical capacity building for the enhancement of institutional capacity in oil spill response for Mauritius. Moreover, the National Coast Guard has set up a dedicated pollution response unit for training and experience sharing by oil spills experts from friendly foreign countries. The other related matters are with respect to regional assistance. Discussions have started with the Indian Ocean Commission for assistance with regards to the setting up of a depot of oil spill equipment. The Ministry of Environment, Solid Waste Management and Climate Change is coordinating in terms of assessment the implementation of an integrated environmental monitoring plan to inter alia, monitor the local ecosystem, track its progress towards improved environmental status in the medium and long term, and make recommendations on the restoration techniques to support its recovery. The National Oil Spill Contingency Plan 2003 has been reviewed in 2023 after consultations with all stakeholders concerned. Consultancy support for the Coastal Sensitivity Atlas for other sites has been secured to review and update the oil spill sensitivity maps and tactical and operational maps at 2 sites, namely from Pointe-aux-Canonniers to Le Goulet and from Montaille-Jacot to Le Maune, and consultancy services for the enhancement of oil spill response has been secured from Agence Française de Développement. Claims to be made to this effect, an environmental and socio-economic impact assessment to gauge the impacts caused by the grounding of MV Wakashio and of the ensuing oil spill on the environment and on the economic, social, agricultural, health, leisure, cultural, and heritage sectors is being undertaken. This is a complex exercise, and therefore the services of a consultant from WHO is awaited to carry out a public health impact assessment. Concurrently, the Attorney General's Office is working on the part of the report concerning the final compilation, documentation, and preparation for submission of claims. Mr. Speaker, sir, I wish to reassure the House that work is in progress for the implementation of the remaining recommendations contained in the report of the Court of Investigation into the grounding of MV Wakashio. Furthermore, the Interministerial Committee will pursue its assignment, while the Technical Committee will be meeting again shortly to gauge on the progress made by the different ministries and departments for the implementation of the recommendations. In this regard, my office is coordinating with the relevant stakeholders to ensure that necessary actions are taken at their end to ensure the implementation of the recommendations contained in the report. Mr. Speaker, sir, with regard to Part B of the question, Government has decided not to make the report public. In the report, it was recommended that some of the matters be referred to the Director of Public Prosecutions for any action deemed necessary. I am informed that the necessary step has already been initiated by the Attorney General's Office. In addition, Government has made claims for reimbursement of expenditures incurred, and authorities concerned, including the Attorney General's Office, is finalizing the claims for compensation. Therefore, it would not be appropriate to table a copy of the report at this stage, as it may cause prejudice to the initiatives taken so far. Thank you.
Oui, comme le Premier ministre l'a dit lui-même, les thèmes de référence sont très vastes et vont de l'échouage du Wakashio jusqu'à la dégradation des écosystèmes marins en passant par la décision de s'aborder une partie du bateau. Donc le Premier ministre peut-il nous dire s'il est au courant que lorsqu'il prend la décision unilatérale de garder secret le rapport de la Cour d'investigation, il agit contre l'intérêt des milliers de victimes, que ce soit des plaisanciers, les pêcheurs, les habitants, qui souhaiteraient pouvoir entamer des démarches légales. Il les prive de moyens légaux de pouvoir demander des dédommagements. Et en même temps, agit de manière antipatriotique également.
Ce n'est pas correct du tout de dire ça, Monsieur le Président, parce que tous les partis qui ont été affectés par le oil spill de MV Wakashio ont fait et peuvent toujours faire des réclamations au gouvernement et dont le gouvernement est en train, je viens de répondre, je crois que l'honorable membre n'écoute pas, qu'on est en train de compiler toutes ces réclamations pour éventuellement pouvoir réclamer à l'assurance et aux propriétaires, and whoever, depending on what advice we get from our legal advisor, we will claim all those amounts to the relevant persons. And let me say again, c'est pas une décision unilatérale. Qu'est-ce que l'honorable membre pense? Que je décide par moi-même? Nous avons non seulement un conseil des ministres, un gouvernement, mais je me réfère déjà à l'avis légal que nous avons reçu. Et nous avons agi d'après l'avis légal. And let me repeat again what I've stated. The Court of Investigation report had recommended inquiries on certain aspects. Those parts of the report have been referred by the Attorney General's Office to the Director of Public Prosecutions on the 9th of February 2023 for necessary action. The report of the Court of Investigation has not been disclosed so as not to jeopardize any further investigations by the relevant authorities. And furthermore, the state of Mauritius wishes to lodge a case against the interested parties responsible for the grounding and ensuing oil spill. Therefore, Mr. Speaker, sir, disclosing the report would be disclosing the approach that the state will take to pursue its claim against the interested parties. And I hope the honourable member will understand, especially when there are evidence that are contained in the report where people have deponed, and now if those evidence are in the public domain, well, this will clearly, I mean, any lawyer will know, this will clearly jeopardize any action that may be advised to be taken by the DPP.
Je comprends surtout que ce n'est pas dans l'intérêt des victimes que de ne pas avoir accès au contenu de ce rapport pour pouvoir entamer des démarches légales. Le Premier ministre peut-il nous dire si la responsabilité de ces ministres, notamment le ministre de la Pêche et celui de l'Environnement, a été engagée dans le contenu du rapport de la Cour d'investigation par rapport aux termes de référence B, C, D et F?
Mr. Speaker, sir, well, we know what kind of demagogy the opposition always comes up with. I have answered and I have stated why is it that this report cannot be made public at this stage. Of course, when the time comes when this is not going to cause any prejudice at all, of course it will then, government will decide then whether to make it public. So at this stage, I have already answered. Now, more so, why is it that we have to be very careful in making this report public? We have already claimed part of the reimbursement of expenditures that have been incurred. In fact, I think we have made a claim for an amount of 540 million rupees, out of which only 60 million rupees have been paid so far. This is what I've been informed. Now, what has been undertaken by the insurance company in the meantime? Surprising, maybe not for some. The insurance company, Wakashio Maritime Corporation, in the meantime, had lodged a case before the Supreme Court in November 2021 for the setting up of a limitation fund in the sum of 719 million rupees. I can inform the House, so far, we have compiled a claim of nearly 2.3 billion rupees. And this is the kind of action that is being undertaken by the insurance company. Now the honorable member wants us to make this report public, in what interest it will be? Clearly, we know in the interest of the one who is contesting to put a limit on liability.
So we move to the next question, MP2.
B379, thank you.
Mr. Speaker, sir,
Order both
I
sides.
am informed by the Airport Terminal Operations Limited, ATOL, that during the period 2005 to 2013, the following lounges were operational at the Suivez Ramgoolam International Airport. The State Lounge, which was reserved for the President, the Prime Minister, visiting head of states and head of governments, as well as other VVIPs. La Terrasse VIP Lounge, which was used for both arriving and departing VIPs and government officials. It was also used as a commercial lounge for premium passengers. The Amédée Mengar Lounge, which was operated and managed by Air Mauritius and used for its premium passengers, that is, first and business class travelers, as well as frequent flyers. And the General Aviation Mauritius GAM Lounge, which was meant for private jet passengers. It was also used as a commercial lounge. Mr. Speaker, sir, I am further informed that as from September 2013, all terminal operations were transferred to the new terminal, except for the State Lounge, which remained operational in the old terminal. Currently, the following lounges are operational at the Suivez Ramgoolam International Airport: the State Lounge, the VIP Departure and Arrival Lounges, the Amédée Mengar Lounge, the Atoll Lounge, which is operated as a commercial lounge by Atoll, and the Jet Prime Lounge, managed and operated by Jet Prime Limited, and is part of the Airport Holdings Limited. Mr. Speaker, sir, the provision of VIP facilities to government officials, VIPs, and foreign visiting dignitaries is an international practice and is a privilege granted to VIPs and other dignitaries by virtue of their status. It ensures swift immigration formalities, streamlined security processes, and access to exclusive amenities. It has been a long-standing practice in Mauritius as well to grant access to VIP lounge to the head of state, head of government, and other ministers, high-ranking government officials, local dignitaries, members of the diplomatic corps at ambassador level, and foreign visiting dignitaries. Prior to year 2000, access to the lounges was being granted in line with an established list which was based on the table of precedence and also included high-ranking officials from the executive, legislative, and judicial organs of government, the public service, members of the diplomatic corps. VIP facilities were also granted to the next of kin, normally spouse and children of the persons on the approved list. Furthermore, requests emanating from ministers and members of the National Assembly for other persons were considered on a case-to-case basis. Mr. Speaker, sir, in the year 2000, the existing eligibility criteria for the grant of access to the VIP lounges at the Suivez Ramgoolam International Airport was reviewed and approved by the then government, and the established list comprised, amongst others, the following. 1. Heads of states, prime ministers, and ministers, and all members of the National Assembly, as well as their spouse and children. 2. Visiting dignitaries. 3. Senior government officials. 4. Ambassadors and heads of international organizations. 5. Heads of religious bodies. 6. Persons conferred awards such as GOSK and GCSK or equivalent. 7. Chairperson and commissioners and members of the Rodrigues Regional Assembly. 8. Officers of the rank of Deputy Permanent Secretary and above, proceeding on mission. And 9. Other persons as per the discretion of the Prime Minister. Requests from other personalities to access the VIP lounge were also considered by the Prime Minister's office on a case-to-case basis. These dignitaries were allowed to be accompanied in the VIP lounges by meters and greeters. Mr. Speaker, sir, the criteria applicable to obtain access to the VIP lounges at the SSR International Airport from 2005 to 2014 was the same as approved in the year 2000. Mr. Speaker, sir, reply to PQ B192 of 2018, the House was, amongst others, informed that an exercise for the review of the policy regarding access to VIP lounges at the airport had been initiated since 2016 with a view to ensuring more effective control on their utilization, including the prevention of any misuse and abuse of the facilities. In fact, it was noted that cases of abuse and misuse had been identified, whereby people well acquainted with former dignitaries, parliamentarians, and former ministers had been granted VIP facilities despite not being eligible for same, especially during the period 2005 to 2014. Mr. Speaker, sir, my government reviewed the policy regarding access to VIP lounges in 2021, and the main amendments comprise inter alia the following. The number of meters and greeters were limited to 2 persons only, and any additional meter greeter would be required to pay for the facilities. And some categories of persons were added and some were removed from the eligibility list. However, upon request, those removed could be granted fast-track facilities on a case-to-case basis through the normal channel. Alternatively, they could have recourse to private lounges at the airport against payment. The revised eligibility list comprises, amongst others, the following: 1. Heads of states, prime ministers, and ministers, and all members of the National Assembly, as well as their spouse and children. 2. Visiting dignitaries. 3. Senior government officials. 4. Mauritian and foreign ambassadors and high commissioners accredited to Mauritius. 5. Persons who have been conferred award as GOSK and GCSK or equivalent. 6. High-ranking officials drawing basic salary from 94,500 rupees and above. 7. Chairpersons of commissions. 8. Chairperson of and commissioners and members of the Rodrigues Regional Assembly. 9. Officers of the rank of Deputy Permanent Secretary and above, proceeding on mission. 10. Chairpersons of parastatal bodies. And 11. Visiting dignitaries and other persons subject to the approval of the Prime Minister. In 2022, some adjustments were made to the eligibility list by adding chairpersons of tribunals, such as the Public Bodies Appeal Tribunal, the Employment Relations Tribunal, as well as inclusion of former Chief Justice and Minister Councillors of the Ministry of Foreign Affairs, Regional Integration and International Trade. Mr. Speaker, sir, it is worth noting that for security reasons, all passengers, including VIPs, have to go through the walk-through detector and their luggage is screened through X-ray scanner. Meters and greeters also have to go through the walk-through detector, and any handbags are also screened. In addition, officers from the Immigration Services, Anti-Drug and Smuggling Unit, and the Mauritius Revenue Authority are deployed in the VIP lounges to reinforce security. I wish to highlight that since the implementation of these measures, there is in place an improved process at the level of the Home Affairs Division of my office for the grant of access to VIP lounges, such that eligible persons have to make a written request to the Home Affairs Division by way of an application form which was designed for this purpose. The request should be made at least 48 hours before the scheduled arrival departure time. The particulars of meters and greeters should also be submitted, and the requests are scrutinized and approved at the level of the Home Affairs Division in line with established criteria, and the approved list is forwarded to Airports of Mauritius Limited. Mr. Speaker, sir, as highlighted earlier, there have been cases of abuse in regard to access to VIP facilities at the airport in the past. My reply to PQB/316 at the sitting of the 14th of May 2024, I informed the House of the grant of VIP facilities to Mrs. C.L. at the request of Honorable Richard Duval. We know pretty well about this case, whereby the previous government had allowed access to VIP facilities to a person who was involved in drug trafficking. I would also seize this opportunity to add that one person, namely Mrs. Nandani S., who is now abroad, had during the period 2005 to 2014 been granted access to the VIP lounge at SSR International Airport on not less than 89 occasions under the names of NS and NO. Mr. Speaker, sir, I am further informed that such requests for VIP facilities were made by the private office directly to the airport authorities and were not made through the normal channel. Moreover, VIP facilities were granted to other persons close to the former Prime Minister, but who were not eligible for such facilities. It is appalling to note to what extent the grant of VIP facilities had been abused of, and we know who was condoning such practices.
Thank you, Speaker. Can Honourable Prime Minister state whether request for access to La Terrace Lounge in favour of Mrs. CL was made through the private office of the Prime Minister's office?
Mr. Speaker, sir, I am informed that the request for access to La Terrace Lounge in favour of Mrs. CL was made by the then PPS, Honourable Richard Duval, through the Home Affairs Division of the Prime Minister's office. The latter declared in his request that Mrs. CL was his cousin, which was a deliberate false information. And I'm tempted to say that it reminds me of this song, Cousin, Cousine, fais-moi content, belle cousine. I am further informed that the private office was involved, and the then Prime Minister, Dr. Navin Ramgoolam, used his discretion to favorably consider the request of the then PPS Richard Duval and authorized Mrs. CL to access La Terrace Lounge on government hospitality, s'il vous plaît. Mr. Speaker, sir, it is not a secret that the then Prime Minister was acting as if the VIP lounges at the SSR International Airport and the airport itself were his private properties. Most of the time when it concerns his allies, cronies and intimate companions, abuse of privileges was of the order of the day. It is a glaring fact that a drug trafficker was allowed access to a VIP lounge on the discretion of the then Prime Minister. That was how Mauritius was governed under the reign of the Labour Party and their leader, Navin Chandra Ramgoolam.
The table has been advised that PQB 381, 382, 385, 388 have been withdrawn. Time over. Question to other ministers. I now call MP Fukun Basha.
B 389.
Mr. Speaker, sir, according to the WHO, there has been a significant rise in the global cases of dengue exceeding 5 million cases in 2023, compared to the global annual average of 500,000 cases over the past decade, and has been spreading across 129 countries. Moreover, about half of the world's population is now at risk of dengue, with an estimated 100 to 400 million infections occurring each year. This global explosion of cases has been partly attributed to climate change, with a greater intensity of precipitation and torrential rains, the El Nino phenomenon, and the higher average temperatures. For example, in 2023, there were 1.6 million cases of dengue in Brazil, and for the first 2 months of 2024, 1 million cases have been reported thereafter. In the context of the resurgence of dengue fever around the world, stagnant water following cyclones and torrential rains, which contributed towards overgrown vegetation in Mauritius, has accelerated the proliferation of the vector mosquitoes transmitting the dengue virus. These meteorological disturbances will likely continue to influence the evolution of this situation. Mr. Speaker, sir, with regard to dengue fever in Mauritius, the Communicable Diseases Control Unit of my ministry has recorded a total of 18 imported and 134 local cases in 2019, no imported cases, while 228 local cases in 2020, 1 imported case in 2021, no local cases, 14 imported cases in 2022, no local cases, 15 imported cases and 209 local cases in 2023, 13 imported cases and 6,081 local cases as at 19th May 2024, out of which 255 are active. With regard to part A of the question, which pertains to the number of patients with dengue fever hospitalized, prior to 30th January 2024, all dengue fever cases were admitted in health institutions. Therefore, however, following a change in the treatment protocol and the setting up of domiciliary monitoring unit, DMU, in each health region, as from 31st January 2024, patients are being admitted based on a triage method. Since January 2024, 1,247 persons have been hospitalized in both private and public sector. Mr. Speaker, sir, no death attributed to dengue fever was recorded for the years 2019 to 2023. Unfortunately, 8 patients have passed away due to dengue fever since the beginning of this year. Thank you.
Merci. Depuis le début de l'épidémie, il y a eu des milliers de cas confirmés de dengue, mais ce chiffre ne reflète qu'une partie du nombre de cas réels, car ceux qui se soignent par eux-mêmes ne sont pas testés. Est-ce que l'honorable ministre peut nous dire si son ministère est en train de mettre en garde et d'informer le public que, contrairement aux autres virus, les personnes infectées une deuxième fois par la dengue courent un grand risque que la deuxième infection soit sévère. Donc, une deuxième infection risque d'être beaucoup plus mortelle que la première infection. Étant donné ce fait, est-ce que son ministère est en train de faire, qu'est-ce que son ministère est en train de faire pour protéger ceux plus à risque?
Mr. Speaker, sir, the first part of the question is related to the cases, whether patients being treated on their own at home. Dengue is a notifiable disease, and everyone who has contracted dengue, unless you do a test to know whether you are positive of dengue or not. And the test is available only at in the hospitals, in the private clinics. So it is deemed for the doctors to report the cases to the communicable diseases section of my ministry. So it would be unfair to say that majority of people are staying at home unless you have been diagnosed by a doctor, and this is a notifiable disease as per the regulations. The doctor has to notify the disease. Now, the second part of the question is about if someone has contracted the disease for the first time and the second time, whether the risk is more. So far, in Mauritius, we have 8 cases of dengue fever and attributed to death. And all these cases, most of them are associated with comorbidities. So here again, It's not at this time, at this point of time, we can say that yes, those who have contracted dengue for the second time, they are more prone for more severe infections. In fact, if there have been more severe infections, the Ministry of Health would have surely have communication with doctors and all stakeholders so that the second cases to give more attention and probably being a call in centers where they can be kept under observation.
You may ask for clarification.
Yes, est-ce que l'honorable ministre peut nous dire si son ministère a l'intention de considérer le vaccin Denvaxia, qui, d'après l'OMS, est prescrit à ceux qui ont déjà eu la dengue au moins une fois?
Mr. Speaker, sir, the access for the vaccine, the WHO is only giving them to countries where dengue is endemic. So for the time being, unless we will have a recommendation from WHO that this vaccine should be given to especially vulnerable cases or those who have contracted the virus for more than two times, then we can implement such measure. But for the time being, the access for the vaccine is only in countries where dengue is endemic.
Next question, MP Kiran.
B390.
Mr. Speaker, sir, following a video on social media showing a charge nurse in Ward 15 who was allegedly under the influence of alcohol, an inquiry committee was set up by the acting director, regional health director of Victoria Hospital to look into the matter. Pending the report of the inquiry committee, officers who were on duty in that ward during the shift on that day have been transferred to other health institutions. Upon the findings of the inquiry committee, appropriate disciplinary actions, if so warranted, will be initiated against the officer under Section 42 of the Public Service Commission regulations. Mr. Speaker, sir, it's worth highlighting that on 19th March 2024, a one-day training program on the combat against alcohol consumption at workplace was launched by the Ministry of Public Service, Administrative and Institutional Reforms. The primary objective of the workshop was to address the issue of alcohol consumption within the workplace and to develop strategies to combat this problem. The workshop aimed to equip public officers with the skills to identify alcohol-related issues among employees and effectively address them. In the same vein, all regional health directors have been requested to carry close monitoring at all levels with special attention to officers working on night shifts. Moreover, my ministry has set up independent squads to carry out surprise checks in hospitals, especially during night shifts. Thank you.
Monsieur le Président, un tel comportement venant d'un charge nurse, comme l'a si bien précisé l'honorable ministre, pourrait effectivement mettre en danger la vie des patients. De ce fait, ne pense-t-il pas que face à une faute professionnelle aussi grave, son ministère devrait prendre une sanction exemplaire afin de décourager celles et ceux, je dis bien celles et ceux, qui consomment de l'alcool durant les heures de travail dans les hôpitaux?
Yes, Mr. Speaker, sir. Honorable member, I share this view of him that we have to take sanctions, but at the same time, nursing officers, cadres working in the hospital, they have supervision level. For example, the charge nurse is supervised by a ward manager, the ward is supervised by a nursing supervisor, so there is a whole set, clearly established supervising team to supervise not only for alcohol, for behavior of staff, especially working in the health sector, where it is very important to see especially critical patients and so on. Now, we have to also operate under the legal parameters before we assume that someone has taken alcohol and why the behavior is as such. So all that we have to look at it in a holistic way so that we are ensured that and respecting all the Public Service Commission provisions made under such an act before we take any sanctions as appropriate.
MP Bada.
Thank you, Mr. Speaker, sir. My question is B/391.
Mr. Speaker, sir, I am informed by the Sugar Industry Labour Welfare Fund that a bidding exercise was launched in February 2023 in order to secure a venue so as to house the community centre at Sadali Vakwa. The procurement process has already been completed and the centre has now been relocated at Moro Road, Vakwa. Mr. Speaker, sir, I am also informed that the community centre was inaugurated on the 23rd of March this year and is in operation. Thank you.
I have two questions. May I ask the Honourable Minister, one is the current lease of that building, what is the duration of that lease and whether it can be revoked?
I'll try to see whether I've got the information at hand, Mr. Speaker, sir. I can give the House information that the premises are being rented against a monthly payment of 40,000 rupees as recommended by the Valuation Department. Yeah, here it is. The duration of the lease agreement is for a period of 2 years.
Second question, Mr. Speaker, sir.
Please.
Yeah. That community centre, I hope that the Honourable Minister has been advised by the Sugar Industry Labour Fund is too far away for the region of Sadali. May I ask the Honourable Minister whether she can ask the Sugar Industry Labour Welfare Fund to have a meeting with the residents of Sadali on a possibility of relocation nearer to the region?
Mr. Speaker, sir, I thank the member for the question, and I also refer him to my reply of last year to Honourable Fourth Member of for Vakwa Floreal. As a matter of fact, since the 1st of April 2019, the community centre was housed in a rented building at corner Sadali Avenue, as you knew, and the inhabitants, Mr. Speaker, sir, of that locality, particularly the ones that live close to the community centre at that time, were completely against the project. They did not want to have activities stating right in petition that the activities were causing nuisance, disturbance, noise. They complained about the lack of adequate parking facilities. They complained about the road being too narrow. Therefore, Mr. Speaker, sir, the Sugar Industry Labour Welfare Fund, at its 982nd meeting, which was held in 2021, decided to rent a new building to relocate, effectivement, précisément, to rehouse the community centre. And I was there present for the inauguration with my honourable friend, Honourable Itu. So I am very privy to the information about how the community centre is, and I can reassure the House that it is operating nicely.
MP Boulel.
Thank you very much. B/392, please.
Mr. Speaker, sir, the government requested the Development Bank of Mauritius to put the Belal Rehabilitation Loan Scheme for the benefit of planters, breeders, fishermen, and micro-enterprise who have been affected by the cyclone. Under the scheme, potential beneficiary affected by the cyclone would be eligible for a loan facility up to 500,000 rupees at an interest rate of 1% repayable under a period of 4 years. Mr. Speaker, sir, I'm informed that the DBM has approved loan facilities amounting to 24.8 million to 172 registered fishermen for the repairs of their boats, engines, and also the replacement of their fishing crops. And as at date, the bank has already disbursed 22.5 million rupees under this scheme. Mr. Speaker, sir, with regard to financial compensation, government approved 1 million rupees for the payment of a special support of 10,000 rupees to fishermen for repairs to their boats, damaged by the cyclone in addition to the bad weather allowance. The registered fishermen with damaged boats were requested to report to the fisheries post of their locality at latest 9th of February 2024. At the closing date, 66 applications were received for damaged boats. Mr. Speaker, sir, subsequently a survey was carried out by the fisheries protection officers posted in the 13 fisheries posts around the island, accompanied by the officers of the Fishermen Welfare Fund, to confirm the damage reported were in fact caused during Cyclone Belal. Following the survey, report was submitted in April 2024, and 51 fishermen were found eligible. The other 15 boats were damaged due to wear and tear. Arrangements have already been made to effect the payment of $10,000 to each of the 51 fishermen by the end of this week. I'm also informed, also wish to inform the House that the Fishermen Welfare Fund caters for accidentally damaged boats during the performance of fishing activities. The financial assistance is $10,000 per fisherman, and this scheme does not cover boats damaged during the passage of a cyclone. Mr. Speaker, sir, this government has always been proactive in providing financial assistance whenever any natural calamities have occurred, whether it concerns the agricultural sector, the fisheries sector, breeders, beekeepers, and micro enterprises.
There has been complaint that there is undue delay in relation to the 51 fishermen who have been affected.
Yes, Mr. Speaker, as I already said that by the end of this week, all the 51 fishermen will be paid the allowance.
David.
B393.
Mr. Speaker, sir, tenders for the framework agreement for the construction and upgrading of amenities and associated works bearing procurement reference number ENV 2223 Q21 ONB were launched on the 15th of September 2023. The closing date for the submission of proposals was initially scheduled for the 17th of October 2023. However, my ministry took cognizance of several requests for clarifications from prospective bidders and extended the closing date for submission of proposals to the 12th of December 2023. The opening of bids was effected on the 14th of December 2024 at the level of the Central Procurement Board. 8 bids had been received. The bids were evaluated at the level of the Central Procurement Board, and on the 16th of April 2024, it informed my ministry that the board had approved the award of contract for the framework agreement for the construction and upgrading of amenities and associated works for a period of 3 years to the following lowest substantially responsive bidders. Prakash Fulchan Contractor Limited for the amount of 325,478,500 rupees, exclusive of VAT, and First Grade Construction Limited for the amount of 356,458,840, exclusive of VAT, which is 23% higher than the cost estimate and subject to negotiation be carried out as per the Directive number 61 of the Procurement Policy Office at time of call-off. Mr. Speaker, sir, letters of notifications were issued to the successful and unsuccessful bidders on the 26th of April 2024 in accordance with Section 43 of the Public Procurement Act of 2006, and no challenge has been received after the lapse of 7 days notification. The contract for framework agreement for the construction and upgrading of amenities and associated works for a period of 3 years has been awarded to the lowest responsive bidder, Prakash Fulchan Contractor Limited, on the 21st of May 2024. As regards the second bidder, a negotiating team will be set up to negotiate the final contract price in accordance with Directive number 61 of the Procurement Policy Office, so that the final negotiated price is not higher than 15% of the estimated cost.
Monsieur le Président, le document d'appel d'offres précise à la section 1.5 que les travaux seront effectués over the whole island, et à la section 1.6 que pour permettre l'exécution simultanée de ces travaux dans différentes régions, le Framework Agreement devra permettre la sélection d'un maximum de 10 contracteurs. Le ministre peut-il nous expliquer comment et pourquoi son ministère est passé de 10 contracteurs à 2 privilégiés pour 3 ans de travaux?
Monsieur le Président, il n'y a pas de privilégié. Tout le process de...
Let me ask you, Honorable David, to withdraw that word privilegé. You've gone too far. You're insinuating.
Le ministre peut-il nous dire comment, contrairement à l'appel d'offres qui prévoyait 10...
First you withdraw the word.
Je retire le mot privilégié.
So your question remains a question. Okay, Honorable Minister, reply.
Oui, Monsieur le Président, comme je l'ai mentionné dans ma réponse, que les bids were evaluated at the level of the Central Procurement Board, and on the 16th of April 2024, it informed my ministry that the board had approved the award of contract for the framework agreement. Donc, Monsieur le Président, tout le processus d'évaluation a été fait au niveau du Central Procurement Board. Et, comme je l'ai mentionné encore une fois dans ma réponse, il y a eu 8 soumissionnaires, mais il y a seulement 2 qui sont considérés comme responsive. Il y a le premier, où le contrat a été alloué directement. En ce qui concerne le second, du fait que l'offre dépasse les 15%, donc l'offre dépasse de 23%, donc ce qui fait que, selon les directives qui sont prévues par le Procurement Policy Office, Directive 61, et donc dans ce cas de figure, les négociations sont prévues pour qu'on puisse ramener ce chiffre de 23% plus bas.
Clarification.
Nous parlons d'un pactole d'environ 340 millions de roupies répartis sur 36 mois, ce qui fait en moyenne un montant des travaux de 9,4 millions de roupies que se partagent chaque mois 2 chanceux. Puis-je demander au ministre s'il ne voit pas là, dans l'attribution de ce contrat juteux, la perception de favoritisme?
Let me remind you. You can't impute motives. Your question should, please, there is one speaker. Have you paid my money? Do you get my money? You get less. I was telling you, you can't impute motives. Your question should be factual. You can't ask the opinion, the impression of the minister. You can't. This is against his standing order. You know that. So I guess you don't have any supplementary question. You have one? Can you manage one?
Yes.
Please. Oh.
Puis-je demander au ministre comment son ministère compte-t-il s'adapter si l'un des 2 contracteurs, lors des 3 prochaines années, pour 340 millions de roupies de travaux, devait se retrouver débordé par la surcharge des travaux, être à court de main-d'œuvre ou tout simplement se retrouver exclu des marchés publics?
Monsieur le Président, je souhaite ici rassurer l'honorable membre qu'il n'y a pas eu de pactole, ni de jackpot, ni de coffre en ce qui concerne ce tendering procedure. Et je pense que l'honorable membre, qui est très mesuré dans ses propos, doit surtout éviter de mettre en doute la crédibilité du Central Procurement Board. Donc, autre chose que j'aurais souhaité souligner à l'honorable membre, comme c'est prévu dans le Framework Agreement, et c'est prévu, je le mentionne, Monsieur le Président, notwithstanding the award of the Framework Agreement to the respective contractors, the Ministry reserves the right to employ its own workers or another contractor under an entirely separate contract after any bidding exercise. Ce qui fait, Monsieur le Président, il n'y a aucun risque de deadlock, il n'y a aucun risque de monopole, donc le ministère est souverain pour prendre toute décision nécessaire si jamais il y a un blocage au niveau de l'implémentation des projets.
At this stage, I'll suspend the sitting for 1.5 hours.